We were talking the first couple of sessions about marriage in various kinds of ways. We'll get to unmarriage and divorce tonight. But there were a couple of things, especially in some of the slides, that may not have made very much sense to you without me just mentioning one or two things. For example, when we were talking about incest, you will have seen that there was a slide from Margaret Mead, the anthropologist, and she had a very interesting theory that we didn't get to. She said that there should always be a zone in a home in which people might engage in activities that otherwise might have sexual overtones but should not be regarded as such. So, for example, somebody may walk around half-dressed, or they may cuddle in somebody's lap. If we make that a zone in which you can do those kinds of things, but there should be no sexual relations between the parties, then maybe we've got a different concept of incest, not a biological one, not an evolutionary or other kind of thing, but a kind of zone within which things that might otherwise appear to have sexual overtones should be regarded by society as not having those implications. And one court actually picked up on that and made a decision based on her theory. So in addition to all the other theories about incest that we talked about that first time, just keep that one in mind. One of the questions that also comes up is about step-siblings. What happens when, two couples get married, they've had children from their previous marriages, so the two children who are being raised together have no direct biological connection with one another. Should they be barred from getting married? And where the courts have been mostly on that is a function of the age of the children, how long they live together, and whether they live together in the same home for a long period of time as brother and sister. Now, do you think those are good criteria to use for step-sibling relationships? Again, your other theory is biological, and so really won't work there because there isn't that biological connection. I gave you some information about polyamory. The thing I'd like you to consider about that is what we actually talked about with the Lee Marvin case and some of the others. We've seen over the course of time that many arrangements become marriage-like, and that some of the features of marriage get attributed to that, usually by state or local law. Well, what if you've got this polyamory situation, where multiple people, consensual, adult, competent, have a sexual relationship and probably a living relationship with one another? Do you start attributing marriage-like features to that? Tax implications, inheritance, all those features we talked about that go with marriage. Well, some states, and particularly, this happens very interestingly in America in recent times, localities, a couple of towns in Massachusetts, needless to say not within spitting distance of Harvard, are allowing polyamory as marriage-like for certain purposes, like housing situations and even workman's compensation and the like. So are we, just as we had same-sex marriage develop when some of the localities began to regard some of the features of same-sex marriage as marriage-like until they built a whole bunch of the features, and then the Supreme Court, we'll see next week, allowed it generally. The same may be happening with polyamory. And one last thing before we get into our discussions is that last slide that I had showed you, we didn't get to talk about the pink house. Remember, we talked a bit about zoning, and especially in the situation with the East Cleveland situation, where the family was defined in such a way that the woman's grandchild couldn't even live with her. Well, there's a very interesting Supreme Court decision. Normally, under the Fifth Amendment, a town, state, federal government can take property by eminent domain, but they must compensate you fairly for it under the provision of the Fifth Amendment. But in this case, New Haven took a piece of property and shooed away all the people who lived on it, that's where the pink house comes in, and turned that property over to a commercial outfit because they said it would benefit the community as a whole for jobs, for the taxes that would be raised and the like. Now that's very strange because normally you have to devote it to a public purpose, like a highway or something of that sort. In that case, they devoted it to a private outfit, a pharmaceutical company, who in the event never even developed the property. Meanwhile, the lady in the pink house had to move herself and the entire house to another location because she was zoned out in that situation. So there the question is, and we won't get to this terribly much in the next couple of weeks, but keep it in mind, the concept of a community. Do communities have rights, or only individuals and states? And there are some instances where you might want to argue that a community, which is not normally a legal entity in the American conceptualization of things, we're sort of strung out between the individual and the state, but should communities have rights? And that can relate to zoning and the like as well.